1:47 a.m., June 28, 2026. Port of Baltimore, Maryland. A CBP trade specialist named Dana Holloway was 40 minutes into her overnight shift when she pulled up the manifest on Terminal Berth 7. The vessel was the MV Arjand Star, registered in Panama, operated by a Cyprus-based shipping management company inbound from Dubai via the Suez Canal. Declared cargo, industrial electronic components. Consignee, a commercial reseller based in Ontario, Canada. Holloway had been doing this job for 9 years. She'd cleared thousands of manifests on overnight rotation. This one should have taken 4 minutes. It took 4 hours. The discrepancy was small, the kind most people would mark as a data entry error and move on. 3 pallets, labeled as circuit boards and passive electronic components, showed a declared weight of 218 kilograms, but the gross weight on the container's seal certification. A separate document submitted by the shipping agent showed 558 kilograms for those same 3 pallets. 340 kilograms difference on a load described as circuit boards. Circuit boards don't weigh that much, not in those quantities, not packed the way they were described. Holloway flagged the discrepancy for secondary inspection at 1:47 a.m. and entered the notation into CBP's automated targeting system. She expected it to sit in the queue until the morning crew could follow up. Instead, the system kicked back a hit. The Ontario consignee, a company called Nexbridge Technical Solutions, had appeared in a Treasury OFAC advisory circulated internally to CBP and HSI field offices in November 2025. The advisory referenced a network of commercial intermediaries suspected of facilitating the re-export of controlled U.S. origin goods to sanctioned end users. Nexbridge was flagged as a potential downstream recipient, not a confirmed target. Not enough to stop a shipment on its own, but combined with a 340-kilogram weight anomaly on a manifest that didn't add up, that was enough. Holloway called her supervisor. Her supervisor called HSI. By 3 a.m., 12 Homeland Security investigations, special agents from HSI Baltimore's National Security Unit were on site at the Port of Baltimore's Marine Terminal. By 3:22 a.m., the container, a 40-foot steel box marked with the serial designation ARJD 447109, had been pulled from the staging area and moved to a secondary inspection bay under port security cameras. The CBP inspector who opened the first crate did not say anything immediately. She stepped back, looked at what was inside, and then said, "We need to get Commerce on the phone. What was inside those 3 pallets was not circuit boards. 38 sealed crates, each one packed in foam-lined aluminum casings. Each one stenciled with part numbers that an HSI special agent named Carla Reyes recognized before she'd even called the manifest cross-check. She'd seen those part numbers before. In a classified briefing 7 months earlier, the components were military-grade gyroscopic navigation modules and fiber optic guidance system parts, U.S. origin. Originally manufactured by a defense subcontractor based outside of San Antonio, Texas. Export controlled under the International Traffic in Arms Regulations. ITAR Category Exide fire control, rangefinder, and guidance systems. Estimated value of the intercepted components, $4, $2 million. Assessed operational significance, sufficient to upgrade the guidance systems on approximately 60 Iranian-produced Shahed-series drones. 60 drones, with better aim. The part numbers didn't just match a general description of controlled goods. They matched something more specific. A parts list that had been circulating inside the Treasury Department's Office of Foreign Assets Control since a July 2025 advisory on Iranian drone procurement networks. That advisory had identified a category of guidance components being actively sought by Iranian defense procurement through front companies operating in the UAE and Turkey. The components in container ARJD 447109 matched that list in 17 of 23 part numbers. That wasn't coincidence. That was a shopping list being filled. Reyes got the classified advisory pulled and cross-referenced against the seized components within 40 minutes of the crates being opened. By 4:15 a.m., she was on a secure line to HSI headquarters in Washington and to the Commerce Department's Bureau of Industry and Security. The Commerce call was the one that changed the scope of what Baltimore was looking at. BIS had a case file on the UAE-based intermediary, a trading company registered in Dubai called Meridian Gulf Commercial Supplies. The file had been open for 4 months. BIS and HSI's National Security Unit had been tracking Meridian Gulf's procurement patterns since February 2026, when a routine export license review flagged a suspicious purchase order for controlled navigation components submitted through a Texas-based export brokerage. The brokerage, registered in Houston under the name Atlantic Meridian Export Partners, had submitted end-user certificates claiming the components were destined for a commercial aviation maintenance company in Oman. The Omani company existed. It had a real address, a real phone number, and a real website. It also had no aircraft maintenance contracts, no relevant equipment, and no staff with engineering credentials. BIS flagged the end-user certificates as potentially falsified in March 2026 and referred the case to HSI. HSI's National Security Unit opened surveillance on Atlantic Meridian Export Partners and its two principals, a U.S. national named Daniel Kessler operating out of Houston, and a second U.S. national named Marcus Webb, whose listed address was in Edison, New Jersey. The investigators had spent 4 months building the case. They had bank records showing payments from Meridian Gulf Dubai to Atlantic Meridian Houston. They had email intercepts showing coordinated export planning that deliberately avoided ITAR disclosure requirements. They had a detailed picture of how the scheme worked. What they didn't have was the shipment itself. Meridian Gulf had last moved a confirmed consignment in late April 2026. After that, the trail went quiet. The Dubai company stopped using the same shipping channels. The payments became harder to track. Kessler and Webb stopped communicating through the channels HSI had been monitoring. The investigators had spent 7 weeks looking for where the components had gone, whether they'd been held in UAE storage, rerouted through a third country, or already delivered somewhere unreachable. The answer was sitting in a shipping container at the port of Baltimore, labeled as circuit boards, on its way to Ontario. Going through the seizure documentation on this case, one detail kept standing out. The shipment wasn't being sent directly to a sanctioned country. It was going to Canada, a commercial reseller in Ontario. That's the mechanism that made this hard to intercept through normal export screening. The goods were moving toward a legitimate-looking commercial destination, one step further removed from where they were actually headed. That's what made Dana Holloway's weight check the moment that broke the entire chain open. By 5:30 a.m. on June 28th, the question was what to do next. HSI Baltimore had a container full of evidence. They had a case file identifying 2 U.S. nationals running a fraudulent export brokerage. They had a UAE-based intermediary with no physical law enforcement reach. And they had, somewhere at the end of that chain, Iranian end users whose identity and location were assessed but not court-ready proven. What they needed was to move fast enough that Kessler and Webb didn't learn about the seizure before arrest warrants could be executed. Ports generate documentation constantly. Manifests, inspection logs, secondary hold notifications. All of it flows through commercial shipping systems that freight forwarders and brokers can access. Atlantic Meridian Export Partners, as the nominal export broker of record on the shipment, would be notified through standard shipping channels if the container was flagged for an extended secondary hold. HSI had roughly 6 hours before that notification would trigger. Case agent Carla Reyes coordinated with the U.S. Attorney's Office for the District of Maryland starting at 5 a.m. By 7:30 a.m., the federal prosecutor handling national security matters had reviewed the seizure documentation and the existing BIS/HSI case file. By 8:15 a.m., she had called a judge. Arrest warrants for Kessler and Webb were signed by 9:40 a.m. Simultaneously, HSI Baltimore coordinated with HSI Houston, HSI Newark, and the FBI's Counterproliferation Center, which had been monitoring overlapping threads in the Iranian Procurement Advisory Network, for simultaneous arrests in 3 jurisdictions. The operations were scheduled for 2 p.m., a controlled window, business hours, when both principals were assessed to be at their known locations. Kessler at Atlantic Meridian's registered office in Houston's Westheimer corridor. Webb at his Edison, New Jersey residence, which court documents would later identify as also functioning as a secondary document preparation workspace for the brokerage operation. Here's the part that doesn't make sense on the surface. Kessler and Webb weren't hiding. They had a registered business with a street address, a listed phone number. They attended trade association events. They had LinkedIn profiles describing Atlantic Meridian Export Partners as a specialized commercial export facilitation firm serving industrial clients in the Middle East and South Asia. They were operating almost entirely in the open, and they'd been doing it for at least 3 years. That's worth sitting with. This wasn't a shadow operation run by untraceable actors through anonymous channels. It was a registered U.S. business with principals who apparently calculated that the falsified end-user certificate system was reliable enough and enforcement infrequent enough that the risk was manageable. They calculated wrong. At 1:58 p.m. on June 28th, Kessler was at his Houston office when 4 HSI special agents and 2 FBI agents entered the building. He was at his desk. He didn't resist. He asked if he could call his attorney. He was told he could call after processing. At 2:03 p.m. in Edison, New Jersey, Webb answered the door of his residence expecting a package delivery. He saw federal credentials and said, according to the arrest documentation, only, "I thought this was going to be a Tuesday." He was taken into custody without incident. 2 additional arrests followed that afternoon. A freight forwarding agent in Baltimore who had processed the container's customs documentation and had, according to the indictment, knowingly submitted commodity descriptions that didn't match the physical contents. And an employee of Meridian Gulf's Dubai office who happened to be in the United States on a business visa at the time of the seizure. He was arrested at a hotel in the financial district in Manhattan at 4:30 p.m. after HSI coordinated with CBP to ensure he couldn't board an outbound flight. 5 arrests, 4 jurisdictions, 1 afternoon. The network had taken 4 months to map. It came apart in less than 15 hours. But the Dubai arrest was where things got complicated. The individual taken into custody at the Manhattan hotel was identified in court documents as a logistics coordinator for Meridian Gulf Commercial Supplies, the point of contact between the Dubai trading company and the U.S. side export brokers. His arrest was legally clean. He was present in the country on a valid visa and subject to U.S. jurisdiction. But his arrest also meant that everyone who remained at Meridian Gulf in Dubai would know, within hours, that the operation had collapsed. HSI's coordination with Emirati authorities, through attachés at the U.S. Embassy in Abu Dhabi, had been running in parallel since the early morning hours. The request was for UAE cooperation in freezing Meridian Gulf's commercial banking accounts and preserving records before they could be purged. The UAE authorities cooperated. Partially, the accounts were flagged. Some records were preserved. But the principals of Meridian Gulf, the actual directors of the company who had coordinated the procurement and payment structure, were not arrested. UAE law enforcement indicated they were reviewing whether domestic charges could be sustained under UAE commercial law. As of the initial court filings in the U.S. case, no UAE arrests had been made. The chain was cut at a specific link. The American links were in custody. The UAE link was in legal limbo. The Iranian end users, the actual destination for components that could upgrade 60 guidance systems, were beyond the reach of any arrest warrant that would matter. What's most surprising about this case isn't the sophistication of the procurement network. Networks like this are well documented in OFAC and BIS enforcement records going back years. What's surprising is the scale of the domestic exposure. 2 U.S. nationals running a registered business, operating in plain sight, generating enough paperwork and financial trail that the case could be built in 4 months once investigators had the right thread to pull. The thread, in this instance, was a single falsified end-user certificate for an Omani aviation company that didn't have planes. At 11 a.m. on June 30th, 2026, the U.S. Attorney's Office for the District of Maryland, in coordination with the Justice Department's National Security Division, announced federal charges against 5 defendants. The charges were filed under the Export Control Reform Act, the International Emergency Economic Powers Act, and, for Kessler and Webb specifically, conspiracy to violate U.S. sanctions regulations targeting Iran. The indictment described Atlantic Meridian Export Partners as a deliberate and sustained export control evasion operation that had, over an estimated 32 months, facilitated the export of at least 11 separate shipments of controlled U.S. origin goods through falsified documentation. 11 shipments. The Baltimore container was the one that got stopped. The court documents were careful not to state definitively what had happened to the other 10. Here's a take that'll probably get some pushback. The fact that this network operated for nearly 3 years before being disrupted is not primarily a failure of HSI or BIS. Those agencies caught it once they had a solid thread. It's a failure of the export licensing and end-user verification system that allowed falsified certificates to pass through review for 32 months without generating an earlier flag. The Omani aviation company that didn't have planes had been the stated end user on at least 3 prior shipments. 3 times that certificate went through. The 4th time, BIS flagged it. 3 shipments of what, exactly, reached where they were supposed to go? That question doesn't appear to have a public answer. Kessler and Webb made their initial appearances in federal court in Houston and Newark respectively on June 29, 2026. Both were held without bail pending a detention hearing, with prosecutors arguing flight risk based on the international scope of the operation and evidence of overseas financial accounts. Kessler's bail hearing was held on July 2nd. His defense attorney argued that Kessler had no prior criminal record, had been a U.S. resident his entire life, had no foreign citizenship, and had surrendered without any attempt to flee despite being in his office when agents arrived. A fact that, the attorney suggested, indicated consciousness of innocence rather than guilt. The prosecutor responded that the investigation had identified wire transfers from accounts in Cyprus and Georgia, the country, into accounts connected to Kessler's personal finances. The judge denied bail. Webb's detention hearing was July 3rd. Similar arguments, similar result. The judge in New Jersey noted that the specific charges, IEEPA violations in the context of Iranian sanctions, carried a potential sentence of up to 20 years per count. Webb was remanded. The freight forwarder arrested in Baltimore, identified in court documents as a naturalized U.S. citizen with prior employment at 3 major international shipping companies, faced separate charges of submitting false customs declarations. His attorney indicated he intended to cooperate with the government's broader investigation. No cooperation agreement had been formally announced as of the last public filing. The Dubai logistics coordinator arrested in Manhattan faced the most immediate legal complexity. His attorney filed an emergency motion arguing that his client's presence in the U.S. had been lawful and that his arrest constituted overreach given the primarily overseas nature of his alleged activities. The motion was denied. He was held pending a bail determination that, as of late July 2026, had not yet been scheduled. 4 months of surveillance. The investigators watching Atlantic Meridian's financial flows had developed a detailed picture of the payment architecture, not just the surface-level wire transfers, but the layered structure underneath. Kessler's business operated multiple intermediary entities, one registered in Delaware, one in the British Virgin Islands, one that appeared to exist only as a bank account number in a Latvian financial institution. Payments from Meridian Gulf Dubai moved through the Latvian account, were split between the BVI entity and a direct transfer to Atlantic Meridian's Houston operating account, and were booked in Atlantic Meridian's records as payments for trade facilitation consulting services. On paper, the Houston company was being paid for consulting, not for goods, not for controlled components. For consulting, the actual controlled components. The ones that required ITAR authorization, the ones that required accurate end-user certificates, the ones that an Iranian drone program apparently needed, were purchased separately through a network of domestic electronics suppliers dealing in surplus and secondary market goods. The suppliers were commercial distributors. Some of them may not have known where their goods were ultimately going. That's the architecture that made this scheme difficult to detect through normal transaction screening. The payments looked like consulting fees, and the components moved through legitimate secondary market channels that generate enormous volumes of routine commercial traffic. You're not looking for a single suspicious transaction. You're looking for a pattern across dozens of transactions, multiple entities, and multiple jurisdictions at the same time. What would you have done in CBP Specialist Holloway's position? 4th hour of an overnight shift, a manifest that almost adds up, a flag in the system that isn't definitive? Most people might have logged it for morning follow-up and moved on. That 340-kilogram discrepancy was the seam the entire case was waiting for. The investigating agents described the weight anomaly as a low-probability trigger that cascaded into a high-value interdiction. The technical term for what Holloway found is a targeting anomaly, a single data point that doesn't belong. In this case, that anomaly connected to a classified advisory, which connected to an open BIS case, which connected to 4 months of prior surveillance, which connected to 32 months of undiscovered exports. One weight discrepancy. One overnight shift. One woman who did the math instead of moving on. The BIS investigation into the full scope of Atlantic Meridian's export operations was ongoing as of late July 2026. Investigators were working backward through the company's 32 months of documented activity, attempting to identify each shipment, each declared end user, and where possible, each actual destination. The task was complicated by 2 things. First, many of the falsified end user certificates referenced real companies in real countries with some legitimate commercial activity. Disentangling which shipments were genuine consulting arrangements and which were controlled goods flowing through false documentation required physical verification in multiple jurisdictions, some of which were not cooperative. Second, The Latvian financial institution holding one of the intermediary accounts had begun a legal review of whether it was required to comply with U.S. subpoenas for account records. That review was ongoing. The 11 shipments referenced in the indictment were the confirmed documented cases. The indictment language included the phrase "at minimum," a signal that investigators believed the actual scope may have been larger. There's a line in the charging documents that reads almost like something out of a procurement manual. Defendants systematically identified controlled components through secondary market channels, acquired those components through entities with no apparent national security profile, and routed payments through jurisdictions selected specifically to avoid OFAC and FinCEN transaction monitoring thresholds. That's not improvised. That's designed. Someone understood the compliance architecture well enough to root around it deliberately. Kessler's professional background, according to documents entered into the court record, included 8 years working in export compliance for a defense contractor before he left to start Atlantic Meridian. He knew exactly how the monitoring systems worked. He'd worked inside them. The real question in a case like this isn't how a sophisticated network evades detection for 3 years. The structure they built, BVI entities, Latvian accounts, consulting payment labels, secondary market components, is documented in OFAC enforcement cases going back 15 years. The question is why the known architecture of export control evasion continues to work when the general pattern has been publicly disclosed so many times. The answer is volume. There are thousands of export transactions processed every day, and the compliance burden falls on systems that can only flag statistical anomalies, not intent. Holloway's weight check was doing what algorithms should have caught earlier. The navigation modules and guidance components seized from container ARJD 447109 were transferred to a federal evidence facility in Maryland. They won't be returned to any commercial supply chain. The assessment that they could have upgraded approximately 60 Shahed-series drone guidance systems was provided to the court by a Commerce Department technical expert whose identity was protected by court order. 60 drones. Better aim. Against whatever target a military program decided they were pointing at. That number is in the court record. It's not speculative. A technical expert evaluated the seized components against known drone specifications and produced that assessment under oath. The Ukrainian defense community has been tracking Shahed-series guidance accuracy improvements as a specific operational concern since at least 2025. The accuracy of these systems has improved measurably over 18 months. Part of the ongoing investigative effort is determining whether any of the 10 other Atlantic Meridian shipments contributed to that improvement timeline. That question is open. It may remain open for some time. Is this justice served? 5 arrests, an ongoing investigation, components seized before delivery? Or is it too little, too late against a network that operated for 32 months? Drop your answer in the comments. We read every one. The trial schedule for the 5 defendants remained pending as of late July 2026. Legal proceedings in national security export control cases typically take 12 to 18 months from indictment to trial, assuming no plea agreements. Kessler's attorney had indicated in a court filing that his client was reviewing his options with respect to cooperation. Webb's attorney had said less publicly, but the detention hearing transcript included a moment where Webb, speaking directly to the judge when asked if he understood the charges, said, "I understood what I was doing. I didn't think it would go this far." What he meant by that, whether it was a statement of scope, miscalculation, or something else, was not elaborated. His attorney moved immediately to clarify that the statement was not a legal admission. The judge noted the statement for the record. The 5th defendant, the Dubai logistics coordinator held in Manhattan, remained in federal custody as of the last available filing date. His case raised a separate set of legal questions about extraterritorial jurisdiction and the reach of IEEPA prosecutions against non-U.S. nationals. Legal scholars following the case have noted it may become a significant precedent if it proceeds to trial. Will operations like this happen again? Comment why yes or no. Because the structure that made Atlantic Meridian possible, secondary market procurement, falsified end-user certificates, layered payment channels through low-scrutiny jurisdictions, was not invented by Kessler and Webb. It's been documented, it's been prosecuted, and it keeps being used. The Meridian Gulf principles in Dubai remain unindicted in any U.S. court. The Iranian end users who ordered the components, the entities that actually wanted 60 upgraded drone guidance systems, are identified in classified assessments and remain beyond the reach of any arrest warrant that will see a U.S. courtroom. The components are in a federal evidence facility in Maryland. The demand that created them is still being met through other channels. Subscribe to Bureau Night Shift. We cover the cases that don't make the morning news, and what happens next in the Kessler Webb trial will tell you something important about how seriously the US government intends to prosecute this category of case. One weight discrepancy. One overnight shift. 38 crates of guidance systems that didn't reach their destination. The 10 shipments before this one are still being traced.